Your Honors, Eric Poe on behalf of New Jersey Pure Amicus. As you may recognize, in 2 short years, this is the 3rd time that we've appeared and been granted the honor and privilege to be before you arguing as to why the importance of the affidavit of merit statute is vital for the protection of medical malpractice rates as well as doctors in the state of New Jersey. Contrary to my opposition counsel who tried to argue why we don't have other insurance carriers before us, it is our unique business model where we don't use agents and brokers, and that we actually are the only carrier in the state that employs its own internal law firm to oversee our claims, that we understand the magnitude and why no other carrier has been before us in these 3 other opportunities before you. And we understand, as I said 2 weeks ago, the toll emotionally, financially, and physically that doctors have to embark upon when there's an allegation of medical malpractice. It seems that there's a lot of confusion in the courts because they don't go back to the original holding by this court in 1961 in Sanzari, where it was the first time that the common knowledge doctrine was ever introduced in the context of a medical malpractice case. And in that actual holding by this court in 1961, what seems to be embedded in the decision is that you first must find proximate cause. And there is no dispute on the proximate cause. If you look at all the cases that are before you, in both adversarial as well as our counsel's briefs, you will see that in every one of these cases, what distinguishes this case from those cases is that proximate cause is not even being argued. There's 2 elements in a case for medical malpractice: deviation in the standard of care and proximate cause of that deviation being to the injury of that patient. The reality is that we have 2-year statute of limitations for any reasonable belief that there was an injury that occurred to a patient in this state. The plaintiffs have their own ability to get their own medical records to review. They have HIPAA. All they need to do is actually file, and this is what traditionally happens. They file to every single doctor that's ever been cared for by their client for all the medical records. They review those cases potentially up for 2 years. What I'm saying here is that the common knowledge exception was evolved from 1961 in the Sanzari case. Right. And in that case, the common knowledge exception was one in which they narrowly carved out to say that in the context of whether experts are needed for a trier of fact to determine whether or not a doctor is liable in a case of medical malpractice, right, we'll create this common knowledge exception in that context. We disagree wholeheartedly that the Ferreira Conference is the right forum to address this. Number one, in the Ferreira Conference, as spoken to earlier, the judge doesn't have any idea of what the allegations are contained in the medical record. It's really to determine whether or not there's a defect in the affidavit. Also, more importantly, now this is a very slippery slope. It's not just a slippery slope. I would analogize it to going down, Mount Kilimanjaro in terms of the type of slope that we're talking about here. Now we're asking a judge in a Ferreira Conference to decide what is common knowledge versus what is a medical expert required to actually provide. Our opinion, if we're speaking out of both sides of our mouth in terms of why this is such a common knowledge exception that a layperson of average intelligence can understand it, but at the same point in time we can't find an affidavit from one of the 2.7 million nurses in the United States of America, it seems to be that I don't think the DJ action would take a lot to actually defend, because it's either common knowledge or not. I don't think it would actually be that long for either a motion judge or in a DJ action for them to decide that.
Thank you.
Thank you, Your Honor.